Go ahead and proceed.
Your Honor, it's my motion to dismiss that's pending for hearing today. The issue before the court, Your Honor, is that on the pleadings which were filed, the plaintiff is asking the court to take the language in my client's trademark and prevent her from using bad girl biker clique in her operations of a women's motorcycle club. Unfortunately, she is the one who has the trademark. She has tendered a trademark before the court, and in our motion, Your Honor, we presented as what should be Exhibit A. Unfortunately, my computer did something funny, and I have two Exhibit Bs, but the first exhibit there should be Exhibit A. And if the court has looked at what we filed, the court will see that that is a trademark given to Valerie Urquhart for doing business as Bad Girl Biker Clique Women's Motorcycle Club. Plaintiff is also asking the court to prevent my client from using her logo and patch, which is trademarked to her in the same name. The center of that logo, as the court can see in the trademark, is Bad Girl Biker Clique. The WMC is there too, but on the side of the logo. Furthermore, my client has a copyright, which is also Exhibit B before the court in the name Bad Girl Biker Clique WMC. Now, in plaintiff's complaint, plaintiff states, and I'm reading from the complaint, on the last page in his prayer, he's asking this court to order by declaratory judgment that my client, number 4, on the last page, cease from using the Bad Girl Biker Clique name while operating as a women motorcycle club. If this court were to grant the relief that plaintiff is seeking, the plaintiff will be having my client operate a women's motorcycle club without the name that is located inside of her trademark, her logo, and her patch. That is the Bad Girl Biker Clique. That would constitute a material alteration of the trademark, of the copyright. Now, the argument here, Your Honor, is not a question of exclusive jurisdiction. That's not it. The question before the court is one involving the statute that covers alterations and the restriction that courts are prevented from allowing or requiring alterations of a mark. If the court looks at our motion, we cited to 15 USC section 1121B. And so we're asking the court to dismiss plaintiff's claims because what he's asking for is outside the purview of the court's jurisdiction under this statute.
Okay, I'm not sure.
May I respond, Your Honor?
Yeah, go ahead. I'm not sure I fully understand that, but okay.
So in my response, we cite section 15 U.S. Code 1121. Section A says that the federal court has original jurisdiction, not exclusive jurisdiction. The presumption is that both federal and state law have concurrent jurisdiction. 1121B says that no court or no state or other jurisdiction may require an alteration of the mark or making additional changes to the mark. We're not asking that the mark be altered or changes be made to it. What this whole suit about is who has the right to use said mark. Because in this area, it is not first to file, it is first to use. And in our summary judgment response, which was passed by defendant, we had argued specifically that Mr. Ward had been the first right to use in Texas. So while we do not argue that Ms. Urquhart has filed a patent, or I'm sorry, this is not a patent case, this is a mark case. We do not argue that Ms. Urquhart has filed a mark with federal courts, and she can use it everywhere outside of Texas. But the first to use it was Mr. Ward in Texas. And so the whole point about it, and then I cite basically a case out of Virginia that deals with this directly, that talks about how this is concurrent jurisdiction, and unless it's exclusive jurisdiction is established, then states have rights to do it. And it talks about how in patent
Mr.
cases,
Ginsburg, I guess my question, this is to both of you guys, is if there is, I guess I'm trying to figure this out. So if this was exclusive jurisdiction, then the proper remedy, in my opinion, would be a notice of removal, not a motion to dismiss.
May I respond, Your Honor?
Well, hear me out. I'm not finished yet. And so that's kind of my first question is what is the proper remedy? But it sounds like you both agree that there's concurrent jurisdiction in this case. And so I'm not sure what the basis of the motion to dismiss is. The second question I have is that I thought this case, we already had a trial on this case when these parties were pro se. Kind of what's left of the case.
I think you did a temporary injunction, Your Honor, into a trial.
You're right. Never mind. Okay, so forget the second question. The first question then.
Your Honor, I think it's my motion. It's probably best if I answer it.
Okay.
Go ahead.
Well, Your Honor, what I would say is the question that Mr. Ginsburg is answering is not the question that I posed for the court to answer with regard to subject matter jurisdiction. My question and the motion before the court is not about exclusive jurisdiction or concurrent jurisdiction. We're not saying that you don't have jurisdiction over the entire case. My client has counterclaims. We're saying that the remedy, the right of the court to grant the relief that the plaintiff is seeking does not exist because granting it would constitute an alteration of the existing trademark. So that's the question of subject matter jurisdiction. It's now a question of whether the court considers 15 U.S.C. section 1121B to stop the court from granting the plaintiff the relief he is seeking, or whether the court says, well, no, I'm going to just go ahead and hear the trial tomorrow. So plaintiff's counsel is answering a different question. In my motion, I did not raise a question of concurrent or exclusive jurisdiction. We agree that if there were actually competing trademarks before the court,
I guess, Mr. Ginsburg, what remedy are you seeking other than alteration of the?
We're not seeking alteration at all, Judge. The trademark itself, no one's seeking to alter it or amend it in any fashion. It's who has the right to use it. And this is a question of exclusive jurisdiction because the A, which I quoted, says the original jurisdiction relies in federal court. Then it's concurrent with state court. B is the exclusive part that says no state can amend or alter the trademark. That has to be filed in federal court. And that's why it is a jurisdictional argument. And I know you're shaking your head, Iggy, but that's what you've asked for. So to say that because we're asking for ownership of the mark is an alteration of the mark, that's not what this section contemplates. What this section contemplates is adding something to the mark or changing the mark. If you read the next section, the next sentence, it says require alteration or registered mark or require that additions be made to the mark. So it's actually changing of the mark itself, which no one is asking for in this case.
Okay.
May I respond quickly, Your Honor, just to take the court's attention to the actual pleadings. Your Honor, this is a pleading state. We cannot just willy-nilly state things outside the pleadings. I am reading from.
Why don't you share screen? Why don't you share screen?
Pleadings. That's the new court looks at the trade. I'm sorry, Your Honor.
Why don't you share screen, whatever you're reading from, so I can see it?
Oh, Judge, I don't know if the court has the record in front of the court. I'm going to try and see if I can share from here. I'm using a separate computer.
Okay, well let me pull it up then.
Very well, Your Honor.
So what are you reading from exactly?
I'm reading from the last live pleading the plaintiff filed, his amended petition.
What day was that?
21st of October, 2021.
I have it. Let me share screen it.
Thank you.
And it would be the page 4, I believe.
Is this it?
Yes, Your Honor, that's correct. If the court goes to page 4,
It's not numbered. Is this page 4?
that's correct, Your Honor. And that's where he's actually seeking the relief. Look at the last statement there, which is what he wants. If you look at paragraphs 3 and 4, in paragraph 4 specifically, he's saying cease from using the Bad Girl Biker Clique name while she operates as a women's motorcycle club. The trademark is Bad Girl Biker Clique Women's Motorcycle Club. So he wants her to take off the Bad Girl Biker Clique. He gets to use that while her WMC remains. That's an alteration of the mark.
Judge, I'm sorry.
Furthermore,
That's mislabeling what he's asking for. If you look in the body of the document, he's saying return all Bad Girl Biker Clique, and it's Bad Girl Biker Clique is using the euphemism for the trademark that's been filed.
Your Honor, I'll take you to the body also. Because I did the same thing Mr. Ginsburg did. I went into the body to see if I was wrong. If the court looks at paragraph 8.
Yeah, they're not numbered. Where is?
It's on page 3. It's the page immediately before that last page.
It's okay. There it is. Okay.
There it is, Your Honor. And you can see where he's talking about plaintiff's injuries and damages. This is what he's actually asking you to do. He says, and I'm reading, the plaintiff has and will continue to be damaged and injured by the defendant's conduct from the misuse of the club name, Bad Girl Biker Clique, operating as the Bad Girl Biker Clique Women Motorcycle Club. So he's not trying to stop her from operating as a women motorcycle club. He just doesn't want her to use that part of the name. He goes on, he says, I'm prohibited possession of the Bad Girl Biker Clique back patch logo. That's the trademark. That logo is the actual trademark. So he's telling you to sever the Bad Girl Biker Clique. And that's an alteration, Your Honor. So while counsel may understand it one way, the notice before this court, the live pleading, is asking for an alteration. And that's all we are saying. We're saying if he's asking for this, then the court can't grant that relief. And that the authority to deny this falls as a question of subject matter jurisdiction. It will be the same where before a federal court or before you. We're saying you have concurrent jurisdiction to say, hey, I don't have subject matter jurisdiction over alterations.
I guess my question, and maybe I'm just misunderstanding this, is altering the mark include if you tell someone they can't use the name? I guess I've always thought of altering the mark. I haven't had a whole lot of cases on this, but altering the mark is I ordered Coca-Cola to change their logo. Is it broader than that?
Well, Your Honor, altering the mark would be asking Coca-Cola not to use Coke in Coca-Cola. Altering the mark would say, don't use Coca in your Coca-Cola name. If you take any portion out of the trademark, you're altering it. If a trademark has a swerve on it and you take off the swerve and say, okay, you can't use the swerve, you can only use the words, it's an alteration.
Judge,
and they're
sorry, my phone rang.
Okay, so I guess I guess I kind of see what you're saying, that you can't force them to change the mark, which I guess in this case is the patch. I guess I can see that I would not have jurisdiction to do that. I do think that I have jurisdiction over who gets to use the mark, which is kind of how I see it. So to the extent that this is a case, again, because I do think the pleading is not 100% clear, Mr. Ginsburg. So to the extent that the plaintiff is seeking alteration of the mark, that portion of the relief is dismissed. So if you want to prepare an order, since I have you here, let's kind of talk about you guys are set for trial tomorrow?
That's correct, Your Honor.
Well, I have kind of good news, bad news. So I'm going to go ahead and try to share screen so you can see kind of our docket. Or can you see the docket here that starts with Carl Adams versus Carol Kim? Do you see that?
No, but I looked at it earlier today, Judge.
Let me share screen again. Now, can you see it?
Yes.
Yes, Your Honor.
So you can see your currently number 5 on the docket. My intention is to hold these, but again, I'm open to suggestions is that I'm going to meet with all of the cases that are left. And as of right now, there's 9, though I know a couple of these are going to, at least a couple of them are going to go away. We started with 30 last week, so we're down to 9. Did you guys, and I recall that this temporary injunction hearing was one of the only hearings I did in person when COVID was really bad, because it was so hard to see that patch and kind of how it differed from the other patch. Are you guys preferring to have this in person, or do you want to do this remotely, or do you care?
Well, Your Honor, remotely is fine with me because we can tender all of our exhibits. We've sent it to the court reporter. I'm sure both parties can do that, and all the sides will have access to it.
Okay. Mr. Ginsburg, what do you think?
That's fine, Judge. Can I get the court reporter's email just so I can forward it to her? I've got them on where I was going to screen share it, but I'll forward them to her.
Yeah, that's a good idea. Tony, can you put that in the chat? But just be aware that, you know, depending on what happens ahead of you on the docket, there's 5 cases ahead of you. The number 1 case as of this moment is still going, and it could be long. I don't know about the number 2 case. Some of the rest of these I just am not familiar with, but my intention is to meet with that. Just so you know, I'm going to meet with all the attorneys on the case, or all the parties and attorneys on the cases, and try to come up with a schedule for the week to when we try everything. So you two may want to kind of confer on that. My hope is that we can get finished with the first 4 cases on Tuesday, and maybe get to your case on Wednesday, but I don't know that for sure. But it could be that, you know, anyway, just to be kind of aware. How many witnesses do y'all have?
I think just truthfully, I'm gonna have 2, the plaintiff and defendant. I think that's gonna be it.
I think that's pretty much the same for me, Your Honor. This is a pretty,
So it's not going to be, you're not going to bring in a bunch of people from each biker club.
No, Your Honor.
Okay. All right. Well, great, guys. Well, I look forward to seeing you tomorrow.
Your Honor, may I suggest something to make things easier?
Sure.
If you think we're going to get to start on Wednesday, would it not be easier to just reset us for Wednesday morning?
I don't know that for sure, because the number 1 case, the defendants have moved for a continuance. And so if that continuance gets granted, it's very hot. This number 1 case is very hotly contested. I'll just say that. If that case goes away, the other 3 cases may not happen. And so you guys could go on Tuesday. I just don't know. But there's also the possibility that, because I'm just kind of giving you my educated guess, but I don't want to do it until I've talked to all the attorneys, because you may start earlier, you may start later. I'm just kind of giving you an educated guess, because there is a possibility that if, for example, I don't know what's going on with the Stokes v. Taylor case or this next case. And so it could be we don't reach you till Thursday. So that's what my process is. But if you just have 2 parties and you're not dealing with a lot of other people, just kind of let them know it's kind of up in the air when you get reached.
Understood, Your Honor.
All right, guys. Thank you so much. You guys have a great day.
Your Honor, as to the ruling, I have a proposed order on file. Do I amend it to state that you're granting the relief as to any alterations requested?
Yes. Why don't you do this? If you could go ahead and change the order in the following ways. 1, with what you just said, and also at the beginning, say that this was heard on March 13, 2023. Share a copy of the order with Mr. Ginsburg, and then email it and e-file it preferably by tomorrow morning, because potentially the trial could start first thing in the morning. I don't think so, but anyway, just kind of gives you a feel. All right,
sure, between Mr. Ginsburg and I, we can get it filed today.
I have full faith. I have full faith. You guys have a great evening, and I will see you in the morning. Okay?
All right. I'll call you about the order.
Thank you.
When we hang up. Thanks.
Thank you.
Thank you, Your Honor.
All righty.
All right, our next hearing is are both sides here on Hendolph Holdings versus Caldwell?
The defendants are, Your Honor.
The movements are, Your Honor.
Okay. Let me go ahead and get started on this. All right, Tony, let's go on the record on cause number DC 229850 Hendolph Holdings versus Dean Caldwell. Counsel, make your appearances.
Good afternoon, Your Honor. Emily Webb on behalf of the movements, Hendolph Holdings LLC, Christopher Randolph, and Hinda Salmaron.
I'm here with Ms. Webb, Your Honor, Will Snyder.
I'm Kent Davenport, Your Honor, for the defendants.
All right, let's proceed. We're here on a special exception.
Yes, Your Honor. We do have two things before you, the special exceptions and the motion for leave to file an amended declaration. And I think we've reached an agreement with Mr. Davenport on the declaration. So if you'd like, we can address that quickly first.
Is that correct, Mr. Davenport?
It is, Your Honor, provided that the original declaration is not withdrawn.
Is that agreed to, Ms. Webb?
Yes, Your Honor, we're not looking to withdraw it or to seal it. We just wanted to correct the record and amend the declaration in a similar manner to the way you would amend a pleading or any other affidavit. The original would still be on file.
Are you going to prepare an order for my signature?
Yes, Your Honor, I do believe that we have a proposed order for you.
Has it already been submitted?
Yes, Your Honor.
Let me look it up. Is that, I'm not sure. I see it. Let me see. I'm going to share screen this. All right, can you all see that?
Yes,
Yes, Your Honor.
So which order is it that you wanted me to sign? When was it filed?
It was filed. I believe it was filed on Thursday, Your Honor, which would have been the 9th.
The 9th. Is that the proposed scheduling order?
No, Your Honor, I believe it would be one of the non-signed proposed orders.
Proposed,
The one right above, I think.
this one?
There. I think so.
All right, let me see. Above the special exception, okay. Is that it? Let me see. I'm pretty sure this is it. Is that the one you're talking about?
Yes, Your Honor.
Does it need to be changed at all?
No, Your Honor, not that I'm aware. We just want to note that substitute doesn't mean that the original declaration will be sealed or withdrawn.
yeah, my concern, Your Honor, is the last sentence of it on the next page. It says it'll be substituted for, and I just want to make sure that when they say substituted, they don't mean to physically remove the original declaration.
Should we change the word substituted to supplemented?
That's perfect.
That's fine for us, Your Honor.
Well, it does correct a mistake that was in the first one. So I don't want it to be construed as supplementing that particular mistake that it corrects.
Okay, let me look at it then. Okay, it currently says, it is further ordered that amended declaration shall for all purposes be substituted for the declaration of Hinda Solomon originally referenced. So how do you want to change that then? Instead of being substituted, should it have a different word?
I suppose we could work with Mr. Davenport to just say we intend to amend a specific statement in it, which was incorrect. We've corrected it. So that, I mean, that's the intent. It wasn't trying to pull down the entire previous declaration.
Do you want to give me a new order then? And
Your Honor,
Sure.
I have no objection with you just on the word substituted, strike it and write on the word amended, as Mr. Snyder suggested. That's fine with me.
Let me see how that reads. Looks like we got another order up, Your Honor.
I mean, I really think substitute is the right word. If you're getting rid of the previous one, it just has one sentence that's different, or did you just?
Yeah, I mean, that's our intent. I think Mr. Davenport was thinking we wanted to either seal or just prevent him from using the first filed one to somehow, I don't know, impeach, I suppose. And that wasn't our intent. We were just trying to correct a misstatement in the first, which to me, we are moving to substitute. That doesn't preclude him from using the first filed one however he sees fit. We're not trying to extinguish it or pull it down. I mean, it's out there. It's public record.
My concern, Judge, is simply that substitute means like a substitute basketball player or substitute teacher is replace it.
Yeah.
And that was my concern.
What if I said it shall be further ordered that the court will allow the correction to the declaration of Henda Salmaran?
It's fine with me.
I think that sounds okay. Emily, are you fine with that?
Yeah, I think that addresses all that we were trying to do. We're just trying to make sure that we have the record correct going forward, Your Honor.
Further, or that the court will allow the correction of the declaration of still. Okay, yeah, I think that works. All right. Okay, let's go to the second motion.
Yes, Your Honor. So we filed special exceptions really for some basic information, Your Honor. We understand that fair notice is a very liberal pleading standard, and we're not looking for a lot of facts or the who, what, where, when, why of fraud. But our concern is that in the counterclaim that was filed, there's a section that addresses 6 legal theories that I'll touch on it in just a minute. But each of them propounds some sort of fraud without specifying which counter plaintiff is suing which counter defendant. And our concern there is that the narrative prior to that section, while Dean Caldwell is referenced frequently, Linda Caldwell doesn't really make an appearance at all. Airmaster Aerator LLC, one of the counter defendants, was never a party to the operating agreement that was signed. And so we're not easily able to draw a conclusion from the facts section and from those listed claims as to who is actually suing whom. And we do think it's a basic part of fair notice that we understand who it is that's suing you. You shouldn't have to, use an interrogatory to find out who it is that is actually suing you. It's a pretty quick fix. And as far as that portion of it goes, that's all we're requesting. The second thing that we are asking for relates to the legal theories that I mentioned. That section of the counterclaim, it lists 6 different definitions of misrepresentation that come directly from the Texas pattern jury instructions. And as Your Honor is aware, misrepresentation is just one of multiple elements that constitute fraud. And so by just reading the face of the counterclaim, it's hard to determine if there's a single count of fraud, and these are all possible theories, if it's really 6 counts of fraud. We're just asking for some clarification in that. And, it's an ounce of pain now to try and put off a pound of pain later when we're looking at summary judgment or other motion practice, when we're trying to figure out what actually are the causes of action alleged against the counter defendants and how it is that we can contest them.
Okay, response?
Yes, Your Honor. I had a hearing with you earlier and I started into my response and you'd already read everything. So if you've read my answer, I mean, my amended counterclaim, which attaches Exhibit A to my response, if you look at my response in the case, there's nothing I can add to it. If you haven't looked at it yet, I'll be glad to go through it.
Oh, wait, so I read was there an additional, when did you last amend it? I looked at the one that was,
December.
okay, you didn't just amend it.
No, sir, I did.
Yeah.
The one that's that we're talking about was the one that we filed on in December.
All right, so I've looked at it, and I guess my main concern is just, first off, it shouldn't say legal theories. It should say causes of action or counterclaims. So that does need to be changed, in my opinion. But the portion I guess I have a concern about is, I do think like you have common law fraud for intentional misrepresentation, common law fraud for false promise of future acts, common law fraud. You can't just plead it that broadly. So I do think you need to provide for those, not for the breach of contract, but for the fraud. I think you just need to go into a little bit more detail about, well, what is the intentional representation? What is the promise of future acts? It just needs to be clear than it is now. So I'm going to order you to replete as to, I guess, paragraphs 2 through 7, just to go into more detail. I guess.
Your Honor, if I could just add something, I'll do whatever you say. If you want me to repeat it, I'm happy to do it. But there are 2 points. They're not looking at the pleading as a whole. They're looking at 1 page. And I've got 7 pages talking specifically about each representation, who made it, when it was made, how it was made, and how they were false, all through it. And they picked that 1 page, they cherry-picked 1 page. Secondly, with respect to the conclusion that we don't discuss legal theories, we only discuss causes of action. The Texas Supreme Court in 1999 had a case that I've cited in my response, and all they talked about were legal theories. And that's the way I've been practicing law for 43 years. I've never had a special exception raised on. This is my first special exception hearing I've ever been in. And if you look at the background facts that I allege, I think you're going to see that I've alleged these things in detailed information so they can look at them. But again, I'll do whatever you say. If you want me to replete it again, I'll be glad to do it.
I just think you need to, I get that. I've seen that it done. I've never seen it done quite the way you done it usually. But you don't have to restate all of the facts again, but give, like you do it kind of in I think it's the 8th paragraph, you just give an extra sentence, basically. This is going to be a sentence or 2 per section, just saying when they did this, it was an intentional, so they know what's tied to which cause of action, which facts are tied to which cause of action. I haven't read that 1999 or 20, did you say 1999 case?
Yes, sir. It's referenced in my response, and I couriered to you a hard copy of it.
It says legal
Theories.
theories is okay as instead of calling it causes of action.
They didn't say they're okay. What the Supreme Court was talking about were analyzing different legal theories. My point is they did not call them causes of action. They called them legal theories. And that was something that I sent to you on a hard copy. I couriered it late Friday afternoon.
You know what? I don't think that's really the issue here. I just want you to replete that sections 2 through 7. I think it is. I don't really care if it's legal theories. I'm just telling you how I normally see it.
Okay, whatever you want to do. The
So
case is Howdy Motors versus Rodriguez is the Texas Supreme Court case in 1999.
okay, I'll take you on your word on it. I did read everything, but I guess I didn't see that. So 2 through 7 need to be repled. The remainder of the special exceptions are denied. How much time will you need to replete, Mr. Davenport?
A week.
Okay. So prepare a new order, Ms. Webb, share it with Mr. Davenport on this. make sure it says at the beginning that this was heard on March 13, 2023, as opposed to on this date. And when are y'all set for trial?
October.
In December, Your
December.
Honor.
Okay.
I mean,
December 5th.
Yeah, December.
Your Honor, can I clarify something from your ruling? Just because
Sure.
this is the first part of Ms. Webb's argument. I mean, I assume that as part of that order, Mr. Davenport is going to replead to be sure we know who the counter plaintiff is for each cause of action and who the counter defendants are.
Correct.
Okay.
That's part of it. But for just those paragraphs, I said 2 through 7, I think is what I said.
Right.
Those were
Thank
the
you.
only paragraphs we moved on, Your Honor.
Okay.
Okay, and on my week, can I have a week from the date you sign the order so I can see exactly what I've got in writing, exactly what I have to do comply with?
That's completely fair.
Okay.
Ms. Webb, I'd like you to try to prepare that order. I'd like to get the order to me before Friday. So I've had a number of cases where people give me orders 3 months later because they get busy. Ms. Webb, I want you to prepare the order at the beginning. It's the same. This was heard on March 13, 2023. I want you to share it with Mr. Davenport and then get it to me by Friday, okay?
Yes, Your Honor.
Thank you, Your Honor.
One other thing, Your Honor, that's along the lines of your question about the trial setting. And I don't want to argue this today, but I think maybe if Your Honor gave some guidance, we could resolve this. But we have a dispute that if Mr. Davenport wants to set it for a later hearing, we filed a motion on Thursday, so he gets his 3 days notice. I'm not trying to cut him off on that, but we're seeking a Schedule 3 or Level 3 scheduling order, pardon me, and he wants a Level 2. And I think we've got a dispute about that. And once we resolve that dispute, I think most of the other dates will fall in line behind the trial setting.
I'm obviously ruling on it. This seems like a level 3 case to me, but I mean, I'm not ruling on it, but I mean, to the extent that you just want to, shoot from the hip reaction, this seems like a level 3 that you guys probably want to schedule an order on.
Well, yeah, that's fine. I mean, I hope we can resolve it. I just don't want to be back here in 10 days talking about level 2 versus level 3, Your Honor. It's our position that the rule mandates level 3 once we invoke it, and then everything else kind of falls into place, including mandatory deadlines, such as amending the pleadings. But I want to respect Mr. Davenport's right to argue this. I just was hoping maybe we could resolve it without troubling the court with it later on.
Well, my concern, Judge, is that I did not have 3 days notice of a hearing on this.
This is not
It's a level 2 case.
I totally agree with you. I'm not making any rulings. I just
Thank you.
shoot from the hip. That's all it is.
Okay, I wasn't trying to get a ruling. I was hoping to get some guidance, but maybe we'll be back in 10 days. I hope not, but thank you, Your Honor.
Thank you, guys. You have a great rest of your day.
Thank you, Judge.
Thank you, Judge. Sorry, Judge, my Zoom is acting weird.
You don't want to leave, huh?
Apparently not. Oh, gosh. Okay.
I'm going to go ahead and remove you. All right, our next one, let me see if we've had any more cancellations. And we're still on YouTube. Our next hearing's at 3:45.
The 3 o'clock council, they agreed. I don't know about 3:45, but the one you told to come back, they agreed and they're gonna send something in email for him.
Perfect. All right, we'll see you in about 5 minutes. All right, is everyone here?
Megan Dixon for the plaintiff, Your Honor.
Good afternoon, Your Honor. Geronimo Valdez on behalf of defendant ASP Management.
First off, let me see, is there anyone here on the Anka versus Keeling case set for 3:45? I don't see anyone. All right, is everyone that needs to be here for case versus ASP Management here?
Yes, Your Honor.
Yes, Your Honor.
Tony, let's go on the record on DC 195203, case versus ASP Management. Counsel, make your appearances.
This is Megan Dixon on behalf of the plaintiff.
Good afternoon, Your Honor. Geronimo Valdez on behalf of the defendant ASP Management, Inc.
All right, so I've read both sides briefing on this. So the first question I have, and it's no one has really addressed this, is do I even have plenary jurisdiction at this point? Because there was a request for a de novo appeal of the associate judge's order, but that was months ago, and a final judgment was signed at that point. I just don't know if the de novo appeal, does that extend is that like a motion to reinstate, or has anyone briefed that issue or know the answer to that?
I have it. Or go ahead, Mr. Valdez.
Your Honor, I know the answer to it. In preparation for today's hearing, to answer your initial question, it has not been briefed. I filed a de novo appeal, found some case law right on point from the 5th District Court of Appeals written by Judge Moberg, explaining the two ways that a associate judge's judgment can be either appealed or a request for a de novo trial can be had. Ultimately, what occurs is after a de novo appeal a request for a de novo hearing has been filed, until Your Honor signs or affirms or modifies the associate judge's decision, it is not yet final. It does not become final until Your Honor signs it. And that was the specific issue. And I've got the case for you, Your Honor. Bear with me just a second.
Okay.
That's Hull v. Aquin Loan Servicing Company.
Why don't you share screen that so I can see it?
I will, Your Honor. Bear with me just a second. I'm not sure which screen I'm sharing, Your Honor.
You got the right one.
Okay. Is this the Court of Appeals case by Judge Moberg? It is indeed, Your Honor. What this does, and it even, Judge Moberg even discusses how poorly written the statute is. And the 5th District actually walks through the process as to when jurisdiction is acquired by the Court of Appeals, what happens with Your Honor. So I've highlighted a couple of portions there. It says, although the AG may conduct hearings, and can you see that? Do I need a?
I can see it. Okay, keep going down. Keep going down. Okay, go to where it says appellate deadline, go down.
Are you talking about the appellate timetable?
Yeah, that's right.
All right.
Okay, so
You need me to scroll down further, Your Honor? Or-
Yeah, keep going, yeah.
Okay. So the next page.
Okay. No, I think that's it. All right, response, Ms. Dixon?
I don't dispute that.
Okay. All right, so look, what do we need to decide today then?
Your Honor, if I might, what I think we need to decide is, number one, whether or not in my de novo request, whether or not it was appropriate to have this case tried before the bench as opposed to the jury, setting aside whether or not it was referred to the associate judge. I don't have the transcripts, Your Honor, admittedly, but I can assure you that I objected to not having a jury trial. And I said several times during the hearing that I'm not trying this case by consent. What you do have briefed in front of you, Your Honor, are the case law going back and forth with both plaintiff and defendant's position with regard to whether or not the district court can remove, or any court can remove, a case off of the jury docket once it's perfected and go to a bench trial without it being waived or without agreement. And so ultimately, what we ended up doing, Your Honor, and I can give you the chronology, but I think Your Honor pretty much knows what occurred, at least with regard to what plaintiff's position is. I wasn't able to fully explain to the court the chronology on the defendant's side, but on that day, November the 1st, I was in Judge Bellin's court. I was not aware that this had been set for jury trial, excuse me, for bench trial, and I can explain to you why. But needless to say, we did conduct a full evidentiary, what you may call a trial, in front of the associate judge, wherein I objected, saying that I did not, I wasn't participating, and I wasn't waiving.
Was there a court reporter for that?
I believe there was, Your Honor, if I may, I think there was, but I was in Judge Bellin's court in her extra room trying it on a Zoom call because we had a jury waiting outside of her court. So I was on my iPad, and I think I recollect, Ms. Dixon will be able to clarify that. I think there was a court reporter, but I am not certain 100%, Your Honor.
Do you know, Ms. Dixon?
I believe there was, yes, Your Honor.
Okay. Ms. Dixon, what's your position on all this?
Sure. Our position was this case was initially set for trial on the 19th of July. We entered into what we thought was a settlement agreement. It didn't materialize, so we were set on the DWAP docket. I appeared for the DWAP docket. Opposing counsel didn't appear. You set this case back on the trial docket. It was on the non-jury trial docket, and the court submitted the notices that it was on the non-jury trial docket on September 12th. I announced ready on October 31st. Your court coordinator sent an email out stating, here's the link for the non-jury docket. Mr. Valdez acknowledged that this was placed on the non-jury docket, and then we appeared for trial on the 1st. And then that's when Mr. Valdez was in two different courts, and we had a shakeup of whether or not Mr. Valdez was going to be able to attend the trial. But we proceeded with the bench trial, and it wasn't until after the bench trial became underway that he made any kind of comments that he wasn't trying this by consent. And under the rules, I'm the one, or plaintiff was the one who perfected the trial fee and paid the placed this on the trial docket by consent, or I removed it from the jury trial docket on that September 12th hearing that we had at the DWAP docket, and we moved forward. And Your Honor even said, as we were moving this to the associate judge, that Mr. Valdez would not be able to object to us proceeding to this non-jury trial with associate Judge Merritt. So we moved on. And there's cases that
I think what I said, or what I imagine I said, I don't have a specific recollection, is that you can't object to the referral to an associate judge, not that he couldn't object to trying this as a bench trial. And I don't think I would have said that, but if there was a jury demand. So anyway, just to clarify.
Sure. And so in any event, we moved on to the trial and the trial proceeded. And I've cited several cases that stand for the position that Mr. Valdez, his objection was untimely and that we could properly move forward with the non-jury trial.
If I can briefly respond, Your Honor, I can give you some context after having looked at the docket. I think I know what occurred. If I may share my screen, Judge, and if Ms. Dixon has any objection to this chronology, it comes directly from the court's docket, the online docket. It might just give you.
I'll pull up the online docket. When are you talking about?
So the first thing that occurred was there was a jury trial notice that was sent out on May the 23rd of 2022, setting this case for trial on July the 19th of 2022. That trial, we settled on the eve of trial, as Ms. Dixon correctly states. That was set. We notified the court coordinator on 7/19, the very next day, that we had settled the matter. Apparently, a DWAP notice was sent for the hearing that occurred on September the 12th. If you look, Judge, on 8/4, there was a return of unreceived mail, and that admittedly was to the plaintiff. What I'm representing to the court is that I never received notice of a DWAP docket to begin with. So when Ms. Dixon showed up, I don't know what occurred, but what she had done was filed a motion to enforce a settlement agreement. So I don't know exactly why I did not get the notice of the DWAP hearing, Judge, but I didn't show up, and apparently there was some kind of mix-up, and that's some evidence that I may not have gotten the mailed copy of it. I was unaware of the DWAP hearing in which this court apparently took the case off the jury docket and then reset it for a non-jury docket. But Your Honor, the other thing that complicates this is this case was settled. Now, I will admit to you, Your Honor, and Ms. Dixon is absolutely correct. I've sent emails to the clients without disclosing the attorney-client privilege. I could not get a signed settlement agreement back. So the next thing that I knew was on October 31st, I get an email from the court saying, you're set for trial. And my response with context was, Rhonda, I see that I'm on this non-jury docket, but I'm in trial with Judge Bellin. This is the first I've heard of it. I will show up to Judge Hoffman's room and explain this to him. But at that point, I'm sure you were extremely busy, Judge. You then, as my recollection serves me correctly, you referred us to the associate judge, but I never waived my right to a jury trial. So at this point, Judge, I can tell you it appeared that I was not prudent and I was not actively working up the case, but a couple of things happened. One, it settled. Two, I didn't get notice of a DWAP. Three, I think Ms. Dixon will admit.
Mr. Valdez, that you have to, I'm all about giving people the benefit of the doubt, but there's a whole series of things that should have happened. You should have appeared at the DWAP. You say you didn't get it. You should have appeared. You said you didn't get notice of the non-jury. You said you settled the case, but you couldn't get your clients to sign off. I mean, at some point, the court has to do something, or you're then what's the point of anything that we're doing here? And so you had the opportunity to object to it going forward prior to it starting, that this isn't a jury trial and it should be a jury trial. You could have objected and said, hey, you set it for a non-jury. It should have been a jury. It shouldn't go forward this day. You can't wait until midway through trial to say, hey, this should have been a jury trial. And then when you get a bad verdict, then try to appeal it.
Your Honor, if I might, you are correct. I agree with everything that you said, with the exception that when you referred us to the associate judge, I mentioned that, and if I recall correctly, you mentioned to me that the grace that this court has shown, rightfully so, was getting a little thin, and that I should have objected to this before, but I did, Your Honor, and I don't think we were on the record. This was, one of those hearings where you were like, Mr. Valdez, we don't have time for this. I'm sending you over to the associate judge to have this done. Prior to it beginning, Your Honor, I mentioned to the associate judge that I'd not waived the jury trial, and several times throughout the process before judgment was rendered, I mentioned I'm not trying this by consent. So I recognize where you are, Your Honor. I recognize how we got there, but I did not wait until I got a bad result to raise the issue of not waiving the jury trial.
I wasn't there in Judge Merritt's court, and so I don't know what happened exactly, if you raised an objection or not. I don't recall you raising an objection. I don't even remember that this was a jury versus non-jury issue. I think we probably may have talked about that at the DWAP. I mean, I think the frustration that Ms. Dixon has is, that there was ample time to get the settlement documents in, and we've all wasted tremendous amount of court resources, and the Ms. Dixon's clients' resources, because you didn't get the settlement paperwork in. I mean, that's what's caused all of this to happen. Because there should have been, there is no such thing as a motion to enforce the settlement. She would have to amend, file a file a breach of contract case in order to enforce the settlement. Motion for summary judgment. That's the proper procedure, as I understand it.
And Your Honor, to Ms. Dixon's credit, I think that's exactly what she did. She filed both a motion to enforce and leave to add a breach of contract case. That's my understanding. What was heard at the DWAP hearing on September the 12th. Rather than granting the plaintiff the relief that they sought, it was taken off of the jury docket and now placed on a non-jury docket, which I was unaware of because I was not there for reasons that I think I just explained to the court. Is I don't know why, but I'm assuming, without confirming, it may have happened the same way to me with regard to a mailing coming back. And I wasn't aware of that until after I looked at, why do I not know about this? And so on 8/4, there's a return mail. It's not to me, it's to the plaintiff's counsel.
That was to another attorney in my office who was no longer on the case.
So there isn't even a return mail to you then?
There's nothing on the docket for me or for Ms. Dixon. There was a return mail filing of the DWAP hearing that was scheduled for September the 12th that I was unaware of, Your Honor.
Okay, so that was to an attorney that's not even on the case anymore, right?
Correct.
That's my understanding.
Who's not even in the firm. I mean, okay. I thought you said that there was a return mail from you. And that's not the case. As far as the court's docket indicates, that you got notice of the DWAP. There was no return mail to you.
That is correct, Your Honor. I didn't mean to, I thought I was clear about the fact that I never received there's not a return mailer for me. But that same hearing, there's a return mailer on there, and that's the only thing I can think of that might explain how come I didn't get the actual mail.
If I can,
on this particular DWAP hearing, Judge.
if I can, in my response to Mr. Valdez's request for a de novo hearing, I attached an email from Ms. Pinson on September 8th that was sent to the entire DWAP docket with the link showing every case that was on it. And so in addition to the first mailer from the court, there was an additional notice to Mr. Valdez that there was the DWAP hearing with the link. So he had notice of the DWAP hearing and he could have attended, but he chose not to.
Your Honor, I agree with the facts. I disagree with the fact that I chose not to. I was unaware of it, and I don't even want to get into where I was. I was in the ICU, Judge, for several weeks. So I understand that this is a series of unfortunate events that are no fault of Ms. Dixon or of this court. but I'm representing as an officer of the court. I was unaware of that hearing. And at that hearing, even if I had been aware, the relief that should have been granted was what Ms. Dixon requested, not taking us off of the jury docket and putting us back on a non-jury docket.
I don't think that's, I don't think that's, there was not a summary, Ms. Dixon, my recollection that summary judgment was not sent on the dismissal docket, was it?
No, Your Honor, I had filed that motion, I think the day before the DWAP dismissal docket, so that I could kind of give the court an overview of where we were on this case, but it was not set for hearing on either of those motions at the DWAP docket. It was placed back on the trial docket.
I couldn't have granted the relief, Mr. Valdez, that because it wasn't on the docket. It was just a dismissal hearing. And the fact that I don't, did we even discuss, Ms. Dixon, that where we're taking it off the jury docket and put it on a non-jury docket? Was that even discussed?
I can't quite remember exactly what was discussed, but I do know that after we had that hearing, my understanding is that we were now on the non-jury docket and we were proceeding on the non-jury docket.
Okay.
Without being there, Judge, looking at it, it appears that that's what occurred.
So, Ms. Dixon, what do you want to, I mean, whatever I do here, you would have to defend potentially on appeal. This is kind of uncharted waters, I think.
My preference is for you to affirm the AJ's final order and sign off on that. And if we need to take this up on appeal, then we will.
I don't feel comfortable doing that. I do feel comfortable. I'm going to order Mr. Valdez to get the entire transcript of the hearing. It says I have to review it all. It doesn't say I have to rehear it. If I determine that he did properly object prior to the beginning of trial, that there wasn't a jury trial, then that he wanted a jury, then I may order this to a jury trial if he did object on the record. But I'm going to require Mr. Valdez, because this is really all, no offense, all your fault. Then you're going to have to bear the cost of getting the transcript. So, and I'm going to give Mr. Dixon, I want you to prepare an order that he has. I don't know what a reasonable amount of time is here. You have to request the transcript and pay the fee within 2 weeks, and it'll be up to the court reporter to. Tony, are you there? Did you know if you did the transcript for this, or do you know?
It does not sound familiar, but I'd have to look. What was the date
I
of the
believe it
hearing?
was November 1st.
I think that's correct, November 1st.
You want me to look real quickly, Judge?
Yeah, if you don't mind. Is usually usually the associate judge does not have a court reporter.
I'm not seeing it.
Did you guys get a court reporter for it, or?
I did not
think there
request
was a-
one, Judge.
I believe there was a court reporter there.
Your Honor, I think my recollection squares with Miss Dixon's, although, like I said, I was on the iPad in another court, but I feel like I remember a court reporter being there.
But neither of you requested a court reporter?
I did not. I'm not sure what Miss Dixon did, Your Honor.
I would have. Let me see. I don't see anything in my emails, but I'm almost 100% certain that there was a court reporter there.
Okay, let me call Judge Merritt, see if I can reach her.
And I have 2 files for that date. I'll keep looking.
You have 2 files for that date?
Yeah,
What is one of them possibly this?
I'm pulling it up. I'm trying to find it. Okay, it was on my second computer. So yeah, I do have it.
Oh, I'm sorry, just 1 second. Did you say yes, you do have a transcript?
Well, it's not a transcript, but yes, there is a record on it for November the 1st. It was on my second computer, yes.
Okay. All right. So sorry, I was calling you to see if you remember if you had a record, but Tony just found it. So I'll call you later. Okay, Judge Merritt. All right, bye. Okay, so there is a transcript. So Mr. Valdez, you're going to need to request a transcript. Hey, and Mr. Tony, make sure that you let him know what the fee is for that. So Ms. Dixon, you're going to go ahead and prepare an order on that. And then I'll review the transcript. And if there's and that should include also the deposition. There was part of this was done via deposition. Is that right?
Correct.
And part was done. Was the deposition read into the record, or was it?
Yes. It was read into the record.
Okay. All right. So Tony, get me the transcript at Mr. Valdez's expense. He has 2 weeks. If not, I'm going to find that he's waived his right to a de novo appeal.
Your Honor, I will do that immediately. I don't want to represent that I don't need 2 weeks, but it'll be as quickly as possible.
Okay, guys, we'll go from there. And there's no way you guys can settle this. I don't know. I don't understand, Ms. Dix, if you don't believe that he's going to actually settle it, but there's no way to try to get this done.
I don't know, Judge. Prior to even settling the case and getting on the eve of trial, we needed to go to mediation, and I couldn't get him or his client to go to a mediation. This was all settled just between the parties, and I thought we had a deal, but I don't know.
Your Honor, I can tell you that I've represented to the court and to the court coordinator. I don't have a problem with an order entering the amount of the settlement agreement, a breach of contract. At the end of the day, I understand where we are. The clients have already agreed. I can't force the clients to do anything that they told me they would. So I don't know, Your Honor. I'm hoping that they will come to their senses and say, you know what, it's better to go ahead and do what we said we were going to do with expenses that were incurred by Ms. Dixon's client and Ms. Dixon after we failed to get the agreement signed. That's where I was the day before we went to trial, and that's where I am now. And I can confirm with the clients, but I do not blame Ms. Dixon for having concerns that will not occur.
Okay, get me an order, Ms. Dixon, and make sure it says that this was heard on March 13th, 2023, and that it indicates that Mr. Valdez is ordered to get a copy of the transcript from the previous trial. Failure to do so will waive the right to appeal.
Will do.
All right, thank you so much.
Thank you very much, Your Honor. Have a
Talk to
good
you
day.
later. Okay, bye-bye. Tony, Rhonda. So tomorrow we're going to be remote. I think I told you, Tony.